I'm Norman Daniels. It's my pleasure to welcome you. I expect a bunch of people will filter in as the morning goes on. We decided to start now and give Glenn a chance to give a little bit of an overview of what happened yesterday so that everybody is on the same page for today. In case you couldn't be here for the day yesterday. We will follow the agenda as it's listed. There's plenty of breakfast refreshment, and you should feel free to get what you need and bring it to your seat. And so I welcome Glenn, who organized this session of the conference. Glenn, let me just turn it right over to you.
Thanks, Norman. Good morning to everybody. So this will be a little bit like the complete works of Shakespeare abridged, if anybody's ever seen this, except it'll be a little less humorous, right? So this is too many hours, 9 a.m. to 8:30 a.m. to 6 p.m. yesterday in about 5 minutes, but we'll try. So we began the morning session with an attempt to kind of put the problem in context. And here, Sue Denser did a really nice job of showing how the statistical identified lives is actually at the center of a number of the provisions of the Affordable Care Act, which we're now wrangling about in the Supreme Court. Tom Schelling, who of course did the seminal work on this, sort of returned us to that work, and I think actually wonderfully showed the way in which empathy is kind of a two-edged sword in this particular setting. Dave Cutler discussed the way in which economists approach the issue, and in particular the relationship between this and how much we value a year of life and the question of spending priorities, and also reviewed and brought forth a very interesting debate about the ways in which the British versus we value lives. It turns out we think our lives are worth more than British lives, which was interesting to know. Dan Brock then gave us not the 7 deadly sins, but the 7 arguments against a favoritism for identified lives, suggesting that there is no deep reason to favor them, and instead the only reasons to favor them are contingent empirical facts that would have to be proven in a kind of a context-by-context sort of area. We then moved to a second session focusing on decision science and psychology that was really just a wonderful review of what's out there in terms of explaining why we have this preference. I won't say bias because that prejudges the matter. Deborah Small went through a number of her studies which sort of actually formed the basis of her dissertation. The one that I found the most striking was to show how little information was needed to make someone identified. She told us about an experiment involving the dictator game. Someone is given a windfall, someone else is a loser. People are given the option of sharing their spoils with the other individual. In one of the treatments, individuals had to decide before whom they knew they were going to share how much they would share. In the other condition, all they were told was they would be sharing with number 3. There are 10 people in the room, number 3. And they found this small intervention of saying, you'll share with number 3, dramatically increased to a statistically significant extent the amount of sharing that went on, suggesting even a small amount of identification, if you want to call it that, was enough to move us to identified lives and that preference. Jennifer Lerner further discussed some of the research she has done and also tied it into discussions of parallel processing and the 2 systems that Denny Kahneman has now made famous. Amitabh Chandra discussed one particular instantiation of what I think it's fair to say he thought of as a bias in decision-making involving FAA and children sitting on laps, and also the way in which public policy discourse can use the effect one way or the other to try and shape a discussion. Peter Rielton took us a little bit more in the direction of neuroscience, but also in the philosophical realm of trying to understand what it is about this and why it might connect to the early evolutionary environment, and I think really pushed the notion that although the bias in particular instantiations may seem, or the effect may seem like a bias, in fact it may be essential in establishing us as the kinds of beings who can form social relationships, and a kind of, I think, a more abstract justification for the work. We then moved into a session on global health. and in particular, treatment as prevention. So the way in which this was framed is that the old debate was between treatment or prevention. We now have the opportunity to use treatment as prevention in the sense that we could provide antiretroviral therapies to HIV-positive individuals before they would be indicated as a strictly medical matter. There'd be some side effects, but the main benefit would be that we would actually be able to reduce infection rates dramatically, right? So this is a matter of putting people at risk or at discomfort to a greater extent in order to prevent prevention. We had a lively discussion. Max Essex sort of led us through the key studies that had shown this effect and the work that he has done. Till Baringhaus continued that discussion and also navigated us through some of the ethical issues that he's been struggling with in his work in the area. Johan Frick gave us a set of normative arguments to give a caution as to why there may be a problem with treatment as prevention and connecting that to the statistical identified lives. And Jonathan Wolf gave us some reflections on the subject as well, and also some questioning both of the underlying data. And one of the most interesting notions that came out of that discussion for me, other people surely found other things interesting, was the notion of my sexual partner's sexual partner as a particular other, and whether I ought to feel that that's an identified person, whether that's an identified person that ought to motivate me more towards effort, or perhaps less, as some people in the audience might have suggested in their comments. So that was, again, the complete works of Shakespeare, quite abridged. It sets us up, though, and again, just to return maybe to the greater theme of the conference, the question is, you know, there is this phenomenon. We do tend to spend, decide, and the like about identified persons. So up for grabs is both a question of understanding the contexts in which we do it. We're going to talk about law in a minute. Understanding the reasons why we do it from a neurobiological or psychological perspective. And then this afternoon session, as I understand, will be focused again on the question of whether this is something we ought to try to eradicate or whether this is in fact something that might be justified in some circumstances. So with that said, we're now ready to talk to the law panel. We've got a really great gathering today. Matt Adler from the University of Pennsylvania, who technically is a law professor, but in reality I think also is an economics professor and a philosophy professor at the same time in terms of his work, is going to talk to us a little bit about cost-benefit analysis and the way in which the identified versus statistical life problem sort of instantiates itself there. Lisa Heinzerling, who's at Georgetown Law School, is going to teach us about environmental law and the way in which, in the environmental law context, the problem instantiates itself. Wendy Parmet, who is at Northeastern University, is going to tell us about public health law as a setting in which this problem emanates. And I'm going to finish the panel by talking a little bit about justiciability and civil procedure and the way in which the system both instantiates it, but then also through the class action technique may give us opportunities to avoid this problem in the law. So with that, I think I'll turn it over to Matt. Thanks very much, Gwen. See if I can get this going. Okay. So, I'm going to just stand here so I can read this. So yeah, I'm going to talk about a cost-benefit analysis and the problem of statistical identified lives, but just to tell you what I'm going to say before I say it, bit of a roadmap. So standard cost-benefit analysis, as we'll see, without distributive weights, in principle, actually, maybe surprising, has a preference for saving identified lives. But there are lots of difficulties with it, both specific and more generally standard cost-benefit really, I think, lacks normative foundations. The social welfare function approach, something I've written about, building upon lots and lots of other work, I would argue has better normative foundations. And it turns out that various kinds of social welfare functions can actually be mimicked by cost-benefit analysis. Not standard cost-benefit analysis, but cost-benefit analysis with appropriate distributive weights. One such social welfare function is the ex-ante prioritarian social welfare function, which, as we'll see, actually has a preference for saving identified as opposed to statistical lives. But here, too, there's room for a lot more normative conversation. It's seriously contestable,
whether this particular social welfare function, that is this particular kind of distributive weighting scheme for cost benefit, is most attractive by contrast with others. All right, so let me just try to get through that in 20 minutes. Okay, so cost benefit is, I'm just going to be too distracting, is widely used in applied economics. Huge literature, whole journals dedicated to applying cost benefit to one or another aspect of policy, and also increasingly by governments, not just the US, but abroad. So what is cost benefit? Well, if S, the status quo, is some baseline policy, then cost benefit looks at individual willingness to pay or willingness to accept amounts. That's WTP/AI, right? That is a change in some individual I's wealth that makes her indifferent between the policy and S, right? So individual I's willingness to pay or accept amount is just the compensating change in wealth that adjusts for whatever way the policy deviates from baseline. So cost benefit uses various techniques to calculate these, either surveys or behavioral evidence, and then sums them up. Right? Cost benefit just evaluates a policy as compared to the status quo or some other policy by aggregating these individual willingness to pay and accept amounts. So what is VSL, the value of statistical life? A term which I think is, quite, as I think others agree, is very misleading. VSL is simply, right, what is used to translate a small change in individual fatality risk into these willingness to pay and accept amounts, right? So at the bottom there, if we change individual I's probability for survival by delta PI, then that multiplied by her VSLI, right, her value of statistical life becomes her willingness to pay amount, right? So VSL, right, is really the trade-off between wealth and survival risk for small risks, right? It's someone's willingness to pay or accept to reduce her risk or to increase her risk, right, divided by the risk. That's what it is. It's nothing like the willingness to pay for, saving someone who otherwise would die. It's rather, again, the rate of trade-off between small changes in wealth and small changes in fatality risk. Now, this is, not to spend too much time on the math, but this is sort of a standard model of VSL. One can model this with more or less complexity, but a standard sort of simple approach says, let's consider someone who has some chance of PI of surviving the current period. 1 minus PI is her chance of dying, and she has a particular amount of wealth, CI. And then the simple model says, well, okay, so let's say U is her well-being, her utility if she survives, V if she dies. We're going to assume that U of C is greater than V of C, meaning that it's better to live as opposed to dying during the period. U prime of C is the marginal utility of money, so adding to her wealth, at least if she lives, is positive. And what happens if you play this through, and this is sort of the standard model, is you get this expression for VSL, which again is, depends on the individuals. It's not a constant, right? This is a function of the individual's, number one, probability of surviving the period, and number two, the individual's wealth. And at least using the simple form for it, VSL actually increases, right, as the individual's probability of surviving the period decreases. This is sometimes called the dead anyway effect. What happens is that as the probability of surviving decreases, this denominator decreases, which increases VSL. And we can go through the math, but the intuition is that if you are not going to survive the period, the marginal utility of money is less, and so you're more willing to give it away, basically. So there's an odd way in which VSL actually, if we calculate it with heterogeneity on a person-by-person basis, would actually increase for identified victims, namely for people at higher risk of not surviving. VSL, however, has lots of unattractive properties. VSL also increases with wealth, right? If you look at this, it turns out that if CI increases, someone's willingness to pay to reduce risk increases. That's not intuitively attractive. And in practice, government tends not to use different VSL values for different populations, but to use homogeneous values. So that, of course, does not involve any kind of preference for identified lives. All right, so let me just talk now about the social welfare function idea. The social welfare function, again, an idea which has a deep intellectual past, ranks policies as a function of individual utilities. Utilities are measures of well-being, which for purposes of this framework are seen as being interpersonally comparable. And there are lots of different possible functional forms for the social welfare function. I've argued in a long book, which just came out, Well-Being and Fair Distribution, that this has much stronger normative foundations than traditional CBA. There are different kinds of social welfare functions. The two I'm going to focus on here are a utilitarian social welfare function, which simply adds up utility. But what's interesting and important to understand is that this framework is not necessarily utilitarian. Utilitarianism is not sensitive to the distribution of well-being, right? It simply focuses on total well-being. But one can have social welfare functions. So, for example, the so-called prioritarian social welfare function, which is sensitive to equity. Prioritarianism, and I'll have a slide which explains this a little more in a second, rather than summing up utilities, sums a transformation of utilities, the effect of which is to give a preference to well-being changes affecting worse-off individuals. Now, this ties back to cost-benefit because it turns out that lots of different kinds of social welfare functions can be mimicked by cost-benefit analysis, not just sort of simple cost-benefit summing these individual willingness to pay amounts, but cost-benefit with these amounts weighted by a weighting factor. Right? So I'll talk about this approach, but again, this will feed back to cost-benefit. And indeed, there are some governments now, the UK, for example, at least in principle, recommends using cost-benefit with weight. So this is not just a utopian kind of idea. All right, so this is the prioritarian social welfare function, right, which sums this, concave transformation of utility. The effect of that is that if I take someone at a low utility level and I increase her utility by some change, as opposed to taking someone at a higher level and changing her utility by the same change, that is a bigger effect up here, right? And a bigger effect on the social ranking, right? So ceteris paribus, I'm going to prefer to transfer utility, well-being, right, from someone who is at a higher level to someone who is at a lower level. And that is, I think, intuitively attractive, or at least represents a preference for equity. This shows, there are lots of different kinds of social welfare functions. Which we can characterize axiomatically. I can come back to that if you want. There are lots of different axioms, but the crucial axiom, right, and the one that, sorry. I want to go to the back up.
You can go back up?
Yeah.
Sure, just let me know which one.
Yeah, just so what's the control on here? Do it. I'll just use that rather than the clicker.
Sure, you can just go left and right.
Left and right, okay,
Yep.
Thanks. Sorry. Okay, so again, this is the prioritarian social welfare function. This shows there are lots of different social welfare functions, but the crucial axiom in terms of equity is this so-called Pagoo-Dalton axiom, right? What this says is that if we transfer utility from someone at a higher utility level to someone at a lower level, so 2 units, we start here, and we take the individual at utility 4 and move her to 6, the individual here, move her down to 8, that's an improvement, right? And that represents a preference for equity. And again, is one of the things which is characteristic of this prioritarian social welfare function. Okay, so point number 1 is there's a different, now again, this represents a kind of consequentialism and welfarism, but it's quite different than cost-benefit. It also turns out that once we think about applying this idea, not just the ranking of outcomes, but the ranking of policies and uncertainty, there are further complications, right? So focusing on this idea of prioritarianism, right, again, summing transformed utilities, right? If now we're not certain what individual utilities are going to be, there are two ways to do that. There's so-called ex post prioritarianism, right? Which sums across different outcomes, discounting by the probability, and then in each outcome looks at the sum of transformed utilities. And then there's ex ante prioritarianism, which basically sums expected utilities transformed by this function. And again, that's a little complicated, but intuitively the difference is that ex post prioritarianism focuses on the expected distribution of utility. Right? It says for each outcome, for each realized outcome, what is the distribution of utility? Right? And then we're going to sort of sum over those, taking account of the probabilities. Ex ante prioritarianism focuses on the distribution of expected utility. Right? And these turn out to be different approaches. Now this illustrates that, but I want to come to this slide, because this ties us back to risk regulation. In a paper which just came out with Jim Hammett from the Harvard Risk Center here and Nicolas Tresch, who's at Toulouse School of Economics, what we then did was to take this social welfare function framework, in particular utilitarianism, and these two different ways to apply the prioritarian social welfare function, and to compare it to cost-benefit to think about how these different approaches value risk reduction. Right? If we're going to think about the allocation of small changes in survival risk, using on the one hand cost-benefit and using on the other hand this social welfare function framework, either a utilitarian social welfare function or this prioritarian social welfare function with a preference for equity, what does that say about how we allocate risk reduction? So we did that with a simple model, indeed the same simple model that was used earlier to illustrate VSL, right? And the idea is simply that we have some status quo, right, where there are a bunch of individuals and individuals, right? Individual I has survival probability PI, right? You know, with PI she survives the current period, with 1 minus PI she dies, and CI is her current wealth. And then we can ask, let's consider a policy, right, that reduces a given person's risk of dying by some small change delta PI. And we can say, what's the social value of that? Right? These different approaches sort of technically represent different kind of social value functions that ascribe an overall social value to a policy understood as a vector of survival probabilities and wealth. Right? And we can say, all right, for this change in individual survival probability, right, so the policy deviates from baseline by, again, reducing someone's chance of dying during the period by a certain amount, what is the change in social value? And in particular, we can say, what is the change in social value, right, divided by the per unit of change in fatality risk, right? How much does social value increase by reducing someone's chance of dying? And here's what's interesting, I think. We can do that for these different approaches, and we can say, how does that change as a function of individual characteristics, right? So, for example, under one or another of these approaches, right, if we're choosing between reducing, you know, the fatality risk of individual 1 as opposed to individual n, right, how does that depend upon the baseline survival probability and or wealth of the two individuals, right? That's really, I think, interesting, because then we can talk about the preference of these different approaches to delivering risk reduction to one or the other individual. Okay, so those are the numbers, but here's the, I think, the money chart. Right, here is really, I think, what's, you know, if there's anything interesting, what's most interesting from this work. So we looked at these different approaches. Again, these are different kind of welfarist approaches to assigning value to policies, understood as policies which both distribute survival risks among different individuals and distribute wealth. And for all these different approaches, again, we're asking, you know, how does this social value of individual risk reduction, right, the change in social value per unit of risk reduction, how does that depend upon individual characteristics? Number one, we asked, to what extent is that sensitive to individual wealth, right? To what extent does the social value of individual risk reduction increase or decrease with individual wealth? Well, it turns out that for cost benefit and utilitarianism, it increases with wealth. That's intuitively unattractive. For the ex post prioritarian social welfare function, it can actually do either. So you can have a prioritarian social welfare function with sufficient curvature that the social value of risk reduction does not increase with wealth or even decreases with wealth. And here is the direct link to the topic of this conference. We did a similar exercise for, is the social value of risk reduction sensitive to baseline fatality risk? With CBA, it increases. That was the slide I showed earlier about VSL. For the utilitarian and ex post prioritarian social welfare function, the social value of risk reduction does not depend upon the baseline fatality risk of the person whose risk is being reduced. But here, what's interesting is that this ex-ante prioritarian social welfare function, the social value of risk reduction increases, right, as the person's baseline fatality risk increases, and that represents a preference for saving identified lives. So that there's one kind of social welfare function, this equity regarding social welfare function of a prioritarian form, right, applied in this ex-ante manner, which actually prefers to deliver risk reductions to those at higher baseline fatality risk, and in particular to identified victims. All right, so let me show a slide that explains why that is. All right, so again, I think that, this showing the way in which the idea is we have two different individuals with different baseline characteristics, in particular survival probability and wealth. We're thinking about reducing this individual's by fatality risk by a certain amount as opposed to this individual's. What does that comparison depend upon? To what extent is that sensitive to the individual's wealth? To what extent is it sensitive to their baseline fatality risk? So here we have, this is the baseline, right? So these are three different possible states of the world. And 0 means the individual does not survive in that state, is dead. 1 means the individual survives. Right, so we have 3 people who have a 2/3 chance of survival, and then Dan, who's our identified victim. Right? And sorry, I did this alphabetically, not even Freudian. So we have two choices, right? We can deliver a risk reduction of 1/3 to Carl, which is this. So in state C, which has probability 1/3, we save Carl. Or we can deliver the unit of risk reduction to Dan. So in state C, we save Dan instead. Right? So these are, here, we increase Carl's chance of living from 2/3 to 1. Here, we increase Dan's chance of living from 0 to 1/3. Right? The only difference between these two is that in this case, we're saving Carl in this state, and in this case, we're saving Dan. Now, what's interesting is from the perspective of utilitarianism or ex post prioritarianism, they're indifferent, right? These are the same outcomes. So in state A, the same outcome, it's the same outcome, right, in terms of who lives and dies, and similarly for state B. In state C, it's the same outcome just for a permutation, right? In state C, either under policy 1 or 2, there are 3 people who live and 1 who dies. But if you're an ex-ante prioritarian and you're focusing on the distribution of expected utility, right, we're moving here from expected utilities 2/3, 2/3, 1, and 0 to now 2/3, 2/3, 2/3, and 1/3. So there's a transfer of expected utility from Carl at level 1 to Dan at level 0. And if you're an ex-ante prioritarian, that's a good thing. So this captures why this ex-ante prioritarian approach, right, which focuses on the distribution of expected utilities, actually has a preference for saving identified victims. That is to say, more generally, there's a preference for delivering, ceteris paribus, holding constant wealth, right? That can change it. But if everyone has the same wealth and other characteristics, there is a preference for delivering a unit of risk reduction to someone who is at a higher probability of dying as opposed to someone who's a lower probability of dying. And this, the next slide sort of shows the same thing. So this slide is between, it's not a matter of saving the identified victim, Dan, sorry, but delivering a 1/3 reduction fatality risk either to him, right, or to Carl. The preference is to do this. Here, now that we have a possibility, so one policy, here's the baseline, one policy is going to save Dan for sure. Dan's identified victim, now Dan's going to be saved, right? So we've reduced his risk by 1. Or we can allocate that risk reduction among the 3 individuals who are merely statistical victims, right? Alex, Barb, and Carl have a 2/3 chance of survival. There's 1 state in which they die, but 2 states in which they live. So policy 1 simply increases each survival probability by 1/3, right? As opposed to saving Dan for sure. Once again, the utilitarian and ex post social welfare functions are indifferent, right? Because now we simply moved from having 2 individuals die in each state to 1 individual, 2 die in each state, to 3 living in each state. The outcomes are identical, but this ex-ante approach, once more, is going to prefer saving the identified victim, moving from here to here, as opposed to producing 1 expected life saving by saving 3 statistical victims. So, I'll jump over that. But the upshot is that there actually is a way within the social welfare function framework, right, applying it in a particular manner under uncertainty, so caring about equity and focusing on the distribution of expected utilities as opposed to the expected distribution of utility that represents a preference for saving identified lives. Moreover, as my slide earlier showed, depending on the curvature of this function, ex-ante prioritarianism can actually make the social value of risk reduction neutral with respect to individual wealth or even diminishing with respect to individual wealth. So this sounds like a happy story. I mean, if you like the idea of saving statistical lives, preference for identified lives, this sounds like a great thing. Unfortunately, and we can talk more about this in Q&A, I think there are some sort of foundational questions one might raise about this ex-ante framework, and it may well be that if we work through that, the more attractive framework, if one cares about equity, is to have this ex-post prioritarian framework that looks at the expected distribution of utility. And again, if you're doing that, right, you're just indifferent between this and this, right? Because we have, in each state, outcomes of equal social value, and if one follows that approach, then there's no preference for saving identified as opposed to statistical lives. Great. Thank you.
Can I just, okay. Hello, everybody. Good morning. Thank you for coming. Thank you to the organizers of the conference for having this interesting topic as your point of discussion. I'm going to talk about environmental law, and I hope to make 2 points about environmental law in the United States as implemented by the United States Environmental Protection Agency. The first point is that I see in our environmental laws, not totally, not always, but I see a tendency to very much to protect the statistical life, that our laws are very solicitous of the statistical life. And therefore, environmental law provides a possible exception to what I take to be yesterday's agreement that we tend to prefer identified over statistical lives. But, and here's the second point I'm going to make today, in reality, the law and the way that the law is implemented allows many people to die, and many times consciously and deliberately so. And I think this is due, at least in part, to the statistical nature of the lives at stake. You've been hearing me so far, correct? Yes, that would be a shame. I don't think that the way I'll describe the laws are implemented, I don't think we would treat identified lives in the same way. So there's a disconnect, in my opinion, between the apparent protections of the law as written and the protections on the ground. I want to step back for 1 minute and make a claim which I think is an exaggeration, perhaps, but I haven't been able to figure out how it's wrong. So here's the claim, which is that there are no identified lives in environmental law. They're all statistical lives. They're statistical lives before we step in to protect them, and they're statistical lives after they're helped or after they're hurt. This is interesting, at least. In fact, I even think sometimes when problems might be regarded as environmental problems, as soon as a person or a victim is identified, I think we may switch to thinking of it as something other than an environmental problem. We think, oh, that was a consumer problem or a worker safety problem, something like that. So I think it may be that there are no identified lives in environmental law. And indeed, if you look at the nature of environmental law, it really is defined in part by protection of things that are very closely associated with statistical lives. And let me just mention a couple of them. One, it's forward-looking and preventative. It's not backward-looking and compensatory. This tends, I think, to produce a result in which it's statistical, not identified lives that are the subject of the law. The environmental risks are generalized and probabilistic, and they're not individualized and certain. Also tends to make statistical lives the object of our discussion. Pollution-related health problems are common even without pollution. Cancer, heart attacks, bronchitis, asthma, and so forth are common even in the absence of pollution. There is no pollution marker that can tell us whether those common ailments and conditions come from pollution or not in an individual case. And so it is difficult, I would say even impossible, to tell us exactly who has those conditions or diseases, has them because of pollution. And so in my view, the life of environmental law is the statistical life. And again, they are statistical, unidentified, both before we intervene and after we intervene. And environmental law, at least in theory, for the most part, as I've suggested, treats the statistical life very well. So its aim is the protection of statistical life, and it tends to direct the EPA to protect the statistical life really to the hilt. So let me just give you a couple of examples in which I think the standards are explicitly tending toward the result where they are very strict, almost unyieldingly strict. The Clean Air Act, for example, requires the EPA to set national ambient air quality standards for a set of pollutants, and requires EPA to base those standards only on scientific evidence and to consider only science and the protection of public health in setting those standards. Those standards are to protect everybody, the young and old, the healthy and the sick, with no regard to cost. That is a very strict standard. When you have statistical lives at the heart of a system and you have a standard applied nationwide without regard to cost, only scientific evidence, only public health, that is a standard that suggests that the statistical life is indeed very important and well protected. I'll give you another example. When it comes to toxic air pollutants, not the conventional widespread pollutants that are the subject of the Air Quality Standards Program, but air toxics, the agency is charged with setting standards first based on the best technology, and the best is described very specifically, really getting at the top performers in terms of pollution control and spreading those technologies to other sources. But then, after that's done, the agency is charged with looking again and making sure everybody's protected. So once you have installed or required the best technology, then the agency has to go back, figure out the risk remaining, and again, protect public health with a margin of safety. When it comes to cancer risks under that program, the agency is to set new standards if any individual is posed to a risk of more than 1 in a million of getting cancer. The same kind of standard applies with respect to pesticides. We are to be protected, the law tells us, against to a reasonable certainty of no harm. Reasonable certainty of no harm. Think about that. It is an amazing standard. And Congress, in history on the statute setting that standard, talked about a risk of 1 in a million being acceptable. And by all these examples, I could multiply them, but I think the point is clear enough. There is, I think, pervasive in environmental law a real attention to and protection of the lives protected by environmental law. And I've tried to suggest that those lives are entirely statistical lives. And so if you just looked at the law, you would think, wow, here's an exception. Here's an exception to what we talked about yesterday in terms of a distinction between statistical and identified lives. In reality, however, many lives are lost. And many lives are lost consciously, deliberately, sometimes almost self-righteously so by the government. There are a lot of causes of this kind of slippage between what appear to be the dictates of the law and the law as it's implemented and worked out in practice. Some of these, I think, are uninteresting for our purposes, and maybe you'll tell me differently in the Q&A. Some of them have to do with the fact that the agency simply doesn't have the resources to get at every problem. They haven't made a conscious choice to sacrifice lives. But in many cases, the agency looks statistical lives in the eye, so to speak, and says, no, we won't protect you, we won't go that far. And it does so in many cases where there are tens, hundreds, thousands of lives at stake. And so you see, as I say, a slippage between the promise of the law and the law in operation. What's striking about this as well is another feature of environmental law. I think this is probably controversial in most crowds, but let me lay it out and say this is why I find this slippage so surprising in part, which is pollution is a context in which people really are hurting other people. Right? That pollution decisions to operate a particular kind of facility with a particular control technology or not can be expected to produce harm in a population of people. It's not an accident, if you will. It's as if we take one of the examples that kind of frames this conference of baby Jessica, it's as if she didn't fall into the well, but she were just about to be pushed. And we didn't step in. Right? That, to me, is environmental law. That, to me, is the decision faced by regulators when they sit down and say, will we protect these lives against harm at the hands of other people? There are a number of explanations the agency gives for not stepping in to protect tens or hundreds or thousands of people in individual cases. And I think they all connect in one way or another to the fact that statistical lives are at stake, despite what I've said about the law. So let me give you several examples of how the agency gets to this kind of result. One is to look at individual risk, which is what Matt was talking about as the definition he's using of statistical life, risks posed on a population of individuals. The agency will, in thinking, for example, about regulation of air toxics, the program I mentioned before that seems to require regulation really to the limit for air toxics that hurt people, the agency will allow risk so long as it's not over a risk of 100 in 1 million for an individual. And so when they find a risk lower than that, they almost palpably breathe a sigh of relief and declare that the risk is acceptable. Even as in the same paragraph, they're telling the world how many people will die given that individual risk. And so that there it seems to me that the statistical nature of the risk is determinative. It doesn't even seem interesting, really, honestly, to the agency in some of these decisions that they expect people to die. What's more interesting is simply the individual risk. That move is not possible without this being about statistical lives rather than identified lives. Another kind of move, and here I don't even know if this counts as an explanation, but let me offer it to you and say that I think this is one way in which the agency sometimes on its own or induced by others ignores many lives at stake. There are some rules. I was at EPA, I was the head of the Office of Policy and came back to academia about a year and a half ago. And what I noticed when I was there is that there are some rules where the costs are just too big. Period, the end. Just too big, right? Doesn't matter how many lives are at stake, doesn't matter what the benefits are. The costs, just according to calculations by people who matter, are simply too great. And let me offer one example here, and this is a prominent, perhaps a controversial example. Last fall, President Obama directed the administrator of the Environmental Protection Agency to withdraw a national ambient air quality standard for ozone. It said, this is a time of economic uncertainty. We don't want to create regulatory uncertainty. These are tough economic times. Please take back the rule you have sent to my White House for review and do not issue it, right? If you look at the regulatory impact analysis that was submitted to the White House when the White House reviewed that rule, it shows thousands of lives at stake in that rule. That wasn't even part of the discussion. That was not part of the explanation for withdrawing that rule. And so here you have a striking example, a statute really aimed at protecting public health regardless of cost, and yet a directive to withdraw a huge standard solely on the basis of cost, not as compared to benefit, but costs in and of themselves. That is striking. That is something I think we wouldn't see with respect to identified lives. I think it's difficult to imagine a rule that saves 3, 4, 5, 6, 7,000 lives a year if they were identified, simply saying it's too much. It's simply too much. A last kind of explanation for refusing to save lives, even in the face of laws that seem quite protective of statistical life, is that they're simply not worth saving compared to the costs. And here's where the comparison to costs comes in. It's not simply costs alone, but costs as comparison to lives. This analysis, which I agree with Matt, has become pervasive in federal regulatory circles, comes into regulatory policy in environmental law predominantly through White House review of agency rules. As you may know, all major rules are sent to the Office of Management and Budget for review before they're issued, and the White House, through administrations, has long required cost-benefit analysis for those rules. And so for any big rule, EPA faces the question, not necessarily through law, but through the executive orders issued by the president that require this kind of review, is this life-saving worth it in terms of the costs? And so you'll find rules that, if you look at the strictest alternative, would save more lives, and yet an alternative is chosen, again, in the face of a law that doesn't make that the criterion. And I want to just close by mentioning one aspect of this phenomenon, this dynamic, that I think is relevant to our discussion and wouldn't be obvious just looking from the outside at this process. And that is the mindset on the part of the people at the agency charged with protecting human life, and as I say, in many cases, protecting it to the hilt under our law. And that is that from the very moment someone at the Environmental Protection Agency conceives of a rule that would save lives, protect health, protect the environment, at that very moment, they start to think, will OMB clear this rule? Right? Will we ever get this rule out of OMB? And when OMB looks at this rule, what they will be looking at is the comparison between costs and benefits. So that shifts the mindset from one of regulating to the limit, regulating to the hilt, protecting statistical lives as if they're your mother or father or sister or brother, protecting them as if they're identified and sitting in front of you, to one in which they can be shed really easily from a rule. If a lot of costs will be shed and the lives have to go too, that happens easily. It happens in order to save rules. And so you have, and I'll close with this, you have in the end, to me at least, a quite remarkable tension between the dictates of the laws given to the agency personnel who are charged by Congress with implementing the law and the mindset that they have to or have taken on in order to make sure that their rules ultimately see the light of day. So thanks very much.
You know, it's going to take us a second to reboot probably, so I'm going to go Phil Donahue for a moment and see if there's a question of what we've heard thus far that somebody wants to ask. Yeah, great. Not waste an opportunity.
Yeah, this is a question from. This is a question from Matt Adler. So I wish we could see the slide, but anyway.
Yeah.
I wanted to ask you: is it correct to say that one way of characterizing the difference between ex ante prioritarianism and ex post prioritarianism is that ex post prioritarianism is a view which is statewise separable, whereas ex ante prioritarianism is not because of the preference of giving higher. What did I say here? Because of the preference of for reducing risk to people who are at a higher baseline of risk. We have to look across states of the world. What would happen to them?
Exactly.
Yeah. So if that is true, isn't ex post prioritarianism subject to the same kind of critique that Peter Diamond made of Harsanyi's statewide separable utilitarianism? So to just give a very simple example, the example that Diamond used, I imagine we have Alice and Bob in state one of the world. Well, we have a choice between two gambles. On one gamble, Alice would win in both state one and state two of the world. Bob would lose in both. And in the second gamble, Alice wins in state one, Bob loses, and in state two, Bob wins and Alice loses. But for ex post prioritarianism, in virtue of having, they would seem normatively
this is a long conversation about, how to apply these approaches under uncertainty, and I have, there's a literature that Diamond starts about that. In chapter of my book, I spend, a whole chapter talking about that. But I mean, to make your point, so in this case, if we're concerned about states of the world, right, separability says, we move from here to here, and these are equally good outcomes. I mean, it's just 3 people live, and that shouldn't matter, and yet that changes it. And so, intuitively, some people have the intuition that this is a better policy because we're equalizing, in the case you're describing. The problem, and again, this is a longer, the problem with ex ante is this. That is, ex ante can favor a policy that is sure to lead to a worse outcome. There's a countervailing deficit. So this is what I call weak stochastic dominance. So if we start with policy 1 and we shift to policy 2, now what's happened is, so again, these are utilities. So in policy 1, let's say there's a 50% chance of state A, 50% of B. In state A, things are a little unequal. In state B, they're a little more unequal. Now we go to policy 2, and in each state, things are quite unequal, but it's flipped. Now what happens here is, if you think in terms of expected utility, which the ex ante person does, hey, policy 2 looks great. Just by moving policy 1 to policy 2, we have equalized expectations. The problem is, if you're a prioritarian, every outcome of this policy is worse than every outcome of that policy, right? So there's a much longer conversation here, and that's why I say it's not really clear, and we can have this conversation, but so it's true that ex ante has this, the virtue of equalizing effective utilities, but it can also mean that, we're going to choose a policy such that, given our underlying, ranking of outcomes, every possible outcome is worse than the possible outcome of the earlier policy.
So we'll have a full hour for Q&A. I just wanted to use the opportunity once we had to reboot anyways to get a question in. But now Wendy's going to go ahead and do her presentation.
Thank you. Good morning. It's a great honor to be here, and I really want to thank the organizers for this really interesting discussion and conference over the course of the last 2 days. Without knowing what Lisa had said, I find that my own talk is going to somewhat parallel her structure, which I think is not surprising because I'm talking about public health law, which I think of a little bit as perhaps the ancestor of environmental law. And so, like Lisa, I'm going to suggest that public health law offers an alternative to the preference that I think we've all agreed we see for identified lives over statistical lives, but then like Lisa, I'm going to say, well, maybe not so much, or not in reality. And truly, we hadn't planned it that way. So here's the baby Jessica picture, and I want to suggest that public health law offers an alternative to the view that we care more about identified lives than statistical lives for many reasons. And the first, let's see if I can figure out how to do this, is its association with public health and prevention. And we've talked a lot about prevention over the last 2 days, so I'm not going to go through or linger on the reasons why prevention is associated with statistical lives, but certainly public health is associated, with prevention. And public health really, prevention in some ways is the core, is the existential identity of public health, and it's what we think of as distinguishing public health from healthcare and medicine. And so in that sense, it shouldn't be surprising that public health law focuses on prevention and statistical lives. A second reason, though, is that public health, again in opposition to medicine, or in distinction, I guess I should say, tends to focus not on individuals, but on groups, populations. Sometimes these populations are relatively small, maybe everybody in this room, and we're actually therefore probably identifiable, but sometimes the population of the whole, AKA the public. And when we're talking about very large populations, or the population of the whole, well, then almost necessarily everybody within that population is not identifiable. And in addition, and this is getting very close to some of what's been discussed before, in many situations that we're dealing with in public health law, the risks to any one individual in that large population will be very low. So we're talking often about things where there are high risks to the population, but low risks to the unidentified lives in the population. A third reason why public health law may have a respect, if I could call it that, for statistical lives is its reliance on public health, and therefore its reliance on epidemiology, which of course is itself a statistical science. Statistics is the lifeblood of epidemiology, and to the extent that public health law attempts to implement and actualize public health, it's not surprising that there is a comfort with and a concern for statistical lives. But I want to suggest that it's not just public health itself, its practice, the field that supports public health's recognition of statistical lives. It also goes back to public health law. And as I said a moment ago, public health law I think of as the ancestry of environmental law and a lot of the other, we could talk about occupational health and safety law, food and drug law. Public health law has roots in really pre-modern conceptions of the police power. And this is an old branch of our law, illustrated by the old common law maxim, salus populi suprema lex, the well-being of the public, of the whole, is the highest law. And that sense that it's the concern for the whole, not for any identifiable individual, is the source of public health law. Public health law's most famous case, I think, well illustrates this. This is Jacobson versus Massachusetts, a 1905 case coming from right here in Cambridge, which upheld a Cambridge ordinance requiring individuals to be vaccinated for smallpox during an outbreak that was occurring in that period. In Jacobson, the Supreme Court, in a decision written by Justice Harlan, talked about upon the principle of self-defense, of paramount necessity, a community has the right to protect itself against an epidemic of disease which threatens the safety of its members. Notice, critically, although the court did not put it this way, the members who were threatened were, of course, unidentified. The court had no idea who would contract smallpox if Jacobson had not been vaccinated. Indeed, it had no idea what the cost-benefit or how many people would contract smallpox. It's just that risk to the community as a whole, right, that warranted what probably many of us would think of today, a fairly coercive, right, violation of individual autonomy. Henning Jacobson had to submit to smallpox vaccination. Jacobson, which talked about the well-ordered society and recognized the needs of the general public, remains good law, and it's cited very frequently in cases and commentaries on public health law, and we see it in many cases today. Consider the case of J.S. versus City of Newark, a 1993 New Jersey case which upheld the isolation of a man, or basically the quarantining of a man with tuberculosis. The court stated that, quote, the claim of disease in a domestic setting has the same kind of power as the claim of national security in matters relating to foreign policy. Now, I'd like to suggest that in national security cases, we almost never ask about the risk to specific individuals. Indeed, we also almost never ask about cost-benefit analysis, right? It's the risk to the nation, not to identified individuals, which prompts the law's action. And likewise, in public health cases, courts seldom demand the name of identifiable victims. Indeed, consider the contrast to criminal law, which usually requires, not always, I recognize there are many exceptions, but in criminal law, generally there needs to be a body, a victim, to warrant, right, conviction and confinement. In public health law, in contrast, the mere showing of danger to some unidentified person can warrant indefinite detention. Okay? And that said, there are many reasons to believe that public health law itself frequently preferences identified lives over statistical lives, and I would suggest that that preference has been growing over time. The easiest, but I believe the weakest argument to be made for that change, if there is one, is that in public health law cases, certainly since 1905, courts have often protected the civil liberties of individuals who are charged with being some danger to the public. So we now have due process hearings, respect for confidentiality, norms of informed consent, rules against discrimination. All of these are now well-established features of public health law, limiting the power of the health authorities to do what they did in 1905. That's actually not the argument I want to make, although we can talk about it during the Q&A. Instead, I want to suggest two other factors that have propelled a perhaps preference for individual over statistical lives in public health law. And the first arises from changes to public health practice today. Although public health ostensibly seeks to prevent harm to populations, it is increasingly focused on individuals and how they can protect their own health. And this is I don't know if it's very clear here, but a picture of the the campaign that was done for the HPV vaccine, and the campaign is one less. Right? This girl will be one less victim of HPV. What's interesting about this is the transformation from Jacobson's day to thinking about vaccination as protective of the health of the community to thinking about vaccination as protective of the health of the self, who is always identified to the self. And we see this increasingly in public health practice and public health law. We see that the message more and more is how can you protect yourself rather than what actions can be taken to protect the health of populations. Sometimes I would suggest, and there is some ancestry to this, this becomes very closely associated with the flip side, which is blaming or scapegoating, right, the identified perpetrator, or what I have sometimes called the dangerous patient. So to say this is not completely new, here's Mary Malone, AKA Typhoid Mary, right? There's a typhoid epidemic. There were actually lots of people with typhoid, but she became the name in the face of typhoid. More recently, Andrew Speaker made world headlines as the tubercular traveler, the lawyer who went for his honeymoon in Greece while having tuberculosis. And so there's this tendency to see individuals as responsible for their own health and as responsible for our health. Okay? Similarly, individualistic approaches are reflected in public health law's increasing reliance on disclosure laws. And I think, although I can't know how to quantify this, I think perhaps the preferred and most common method in public health law today of protecting the public is to mandate certain disclosures, information, transparency, give people the choice, right? Let's tell people the dangers of cigarettes, the dangers of the calories on the menu, and right, trans fats, we know all of these laws. But again, these approaches don't try to change the environment or the social determinants of health, nor do they actually prioritize statistical lives over identified lives. Instead, they tell individuals who are identified what they themselves can do for themselves. But there's another reason I want to turn to, which is, for lack of a better term, let me call it the structure of the common law. And it's trite but true to note that our legal system prioritizes negative over positive rights. Now, that observation is often made in conjunction with discussions of constitutional rights and the fact that in the United States there's no recognized legal right to health care. But it is tied more broadly and deeply, I think, to the pattern of the common law and the doctrines to which it has bequeathed us. Perhaps the most relevant rule is the common law rule that individuals have no duty to act, the no duty to rescue. And I think it's interesting because yesterday we talked about duty to rescue as protecting identified lives, and I'm going to argue that the no duty to rescue actually protects identified lives. So follow with me. This doctrine played a powerful role, at least rhetorically, if not doctrinally, in the litigation over the Affordable Care Act, and what I am now going to call the broccoli brouhaha. Right? The government can't make us do something, right? There's this distinction people kept saying between action and inaction, right? The government could stop you from doing something if you were in the marketplace, but they can't compel you to do something. Consider the case of AIDS Healthcare Foundation versus Los Angeles County Department of Public Health, a California Court of Appeals case. The California court was asked to issue an order requiring the LA Health Department to promulgate a regulation requiring the use of condoms in the filming of pornography. The court refused to do so. What's interesting about the case is the court never questioned that the regulation might be a great idea, that it might save lots of statistical lives. Nobody talked about the cost, by the way, because, you know, the cost to the porn industry wasn't really the way the court was going to put it, perhaps. Instead, the court refused to issue the writ, noting that the law leaves it to the discretion of the health department of whether to act in particular cases. Okay, so that part of the point I want to make is that public health law gives health agencies power, but not responsibility. A similar pattern appears in tort cases that are brought against health agencies for their failure to act and for harms that have come as a result. At least many of the lawyers in the room are probably familiar with the DeShaney and Castle Rock cases, in which the United States Supreme Court basically said that the 14th Amendment, the Due Process Clause, provides no right to protection from state agencies. Now, it's tempting to view such holdings as specific to constitutional law, to the text of the Due Process Clause, to concerns about federalism, etc. But state common law actually parallels these Supreme Court decisions. For example, many states say that a health department's failure to act is discretionary and subject to governmental immunity, unless an exception can be shown. Other courts in which there's no immunity available will reach similar conclusions through the so-called public duty doctrine. In either case, the analysis is the same. A health agency's failure to act, for example, its failure to investigate a TB epidemic, and therefore protect the people who are at risk from a tubercular traveler or anybody else, is not actionable unless, and here's the interesting unless, the plaintiff, the person who's harmed, who came down with tuberculosis, can show some kind of special relationship. Back to where we were yesterday. And what does that special relationship require? Well, there are several ways you can get there. But one, and perhaps the most important, is that the individual have some contact with the agency and reliance. But the contact is the part I want to talk about, because in effect it means that only when the individual was identifiable to the health agency, had contact, then must the agency act. The combined impact of these various doctrines is that the protection that public health law affords to statistical lives, the protection that the Constitution still permits it to provide under Jacobson, serves primarily to empower government officials to take actions. It provides very little doctrinal support for the claim, frequently made by public health practitioners and bioethicists and human rights advocates, that government has a duty to protect statistical lives. In effect, the language of Jacobson and its progeny is about power, not responsibility. When this doctrinal asymmetry is combined with the increasing propensity of public health policymakers to exercise the power they have through individualistic mechanisms such as disclosure laws that prioritize and speak to the self rather than the environment, public health law's protection for statistical lives is diminished. Despite these significant limitations, public health law does, I continue to believe, offer a foundation for an enhanced recognition of statistical lives in American law. The rhetorical leap from power to duty is not fast, even if the analytical chasm is. Cases and statutes that extol the importance of solus populi continue to provide a compelling alternative discourse for legitimating respect for statistical lives and the public. Equally important, public health law, I think, provides a very powerful retort to those who suggest that interventions on behalf of statistical lives are novel limitations on freedom invented in the 21st century nanny state. Indeed, what a deep examination of public health law shows is that they are well-established parts of our legal legacy and go back as long as do our respects for individual liberty. Although the terms have changed, an examination of public health law reveals that the protection of statistical lives is indeed one of the most ancient and well-established features of our law. Thank you.
Great. Just by show of hands, how many people in the audience are lawyers? Okay, so minority. Well, that's good because a significant portion of my talk is about civil procedure, which is often viewed, especially when taught by me, as one of the more traumatic elements of law school. So that suggests to me that I want to ease you into it a little bit by just suggesting two other interesting contexts that, since we decided to do this conference, have kind of come to my attention of interesting places where this issue comes up. One was suggested actually by my colleague Mark Rowe, who focuses on corporate reorganization and bankruptcy of all things. And he pointed out to me quite correctly, I think, that although we talk about statistical versus identified lives, you could actually put a lot of other things in that last word and talk about entities. So he told me about the way in which we can think of the bailout as for the automakers and the like as a preference for identified companies over statistical companies, which I thought was kind of interesting. The other context that sort of has caught my eye and actually now prompted a paper by me on the subject is legal services and the delivery of legal services, in particular the public defender services or the Harvard Legal Aid Bureau, and basically the way in which what they do in terms of selecting which clients to represent is an instantiation of the problem, in that when they decide to represent somebody on day one who faces a 5-year Class B felony charge, for example, it means necessarily diverting resources from someone who will come later on, and they know what their populations look like as a whole. So kind of another interesting example where there are some similarities to the medical context. Okay. But I'm going to, this is the rare opportunity where civil procedure, which is my bread and butter course, gets to interact with bioethics, so I'm a little bit too excited about this, given that I'm going to be talking about civil procedure. But basically, what I want to try to convince you is that actually adjudication as a process is set up in a way that highly favors identified lives, not for reasons connected to the types of favoritisms that Dan talked about yesterday or that go in the philosophical literature, but actually for entirely orthogonal sets of reasons having to do with separation of powers, having to do with preferences for concreteness and fact development. So under the Constitution, under Article 3 of the Constitution, in order to bring a claim, so one thing that's probably obvious, so obvious that you don't think about it, how does a civil lawsuit begin? It has to begin with somebody bringing it. So right away, there is an individual that has to step forward, right? So right away, at the very beginning, there is a kind of preference built into the system for an identified life. But in order to bring that lawsuit as that individual, in the federal system at least, and in many state systems, under the Constitution, we require what is known as standing and ripeness. And I'm going to argue to you today that both of these elements tilt us towards preference for identified lives in adjudication, but then I'm also going to suggest a way in which a procedural device in civil procedure, the class action device, actually gives us a way of kind of pushing back, and also suggests an intermediate concept between identified and statistical lives, which is the notion of a representative life. Okay. So let me first start with the problem story, which is standing and ripeness. So under the Constitution, in order to bring standing, to have standing, in order to bring a challenge, an individual has to allege a few things. One, and this is the one that's going to be most important for our purposes, he has to show or she has to show that she has suffered or will imminently suffer an injury. Two, the injury has to be fairly traceable to the defendant's conduct. And 3, a favorable ruling is likely to redress the injury, redressability. So those latter 2 requirements are interesting, but I'm not going to focus on them. I'm instead going to focus on that first requirement of an injury, showing an injury that is directly related. So you have to show, in fact, and this is a quote, that he was personally suffered some actual or threatened injury. Turns out that requirement puts a heavy favoritism towards identified lives. And just to show you, I thought I'd tell you about some Supreme Court cases on the subject, many of them from environmental law, that show how people run afoul of this requirement in cases where you might think that actually, if we thought more seriously about statistical lives, we'd want these cases brought. So in an older case, Sierra Club v. Morton, you have the Sierra Club who seeks to prevent the construction of a ski resort. The Supreme Court says there's no standing to bring that claim because the club only alleged sort of a general interest in the conservation of national parks and forests, not that, quote, it or its members would be affected in any of their activities or pastimes by the development. In other words, they had to allege that they would use the park in a way that this development would impede, right? So again, very much making an identification of one's claim. Similar case, Lujan v. National Wildlife Federation. The Federation challenges lessening wildlife protection, but again, the Supreme Court says they lack standing because they hadn't alleged that the specific federal land that was going to be mined under the new regulations was one that they intended to use, right? So you can't just bring a general complaint that I don't like this mining regulation or that it's going to set back the environment. What you need to do is to say this is a place where I vacation with my family, for example. Another case outside of environmental law, United States v. Hayes. So the question here was whether redistricting of an election district on racial grounds violated the Equal Protection Clause. So what the court says was that the only person who could act as a plaintiff, the only one who would have standing, is someone who currently resides in the racially gerrymandered district and can challenge the legislature's action, not someone who currently lives outside of it. So again, it's hyper-identification. It's not that those people outside the district have no interest in avoiding racial gerrymanders or the like, but instead this view that only someone who's directly affected by the action at issue can face it. One more, that's my favorite actually because it's the most extreme in some ways, of the notion of purposefully suffering a harm and the notion of current versus future, which is also something that came up in our discussions. This is the case of Los Angeles v. Lyons. So the plaintiff wanted to enjoin the LAPD from engaging in chokeholds as part of its basic plan for arresting individuals. The person who brought the action, Mr. Lyons, 24-year-old black man, he'd been stopped for having a burnt-out taillight in his car and chokeholded while handcuffed and started spitting up blood and was then, at the end of this interaction, if you will, only given a traffic citation, right? So he was chokeholded as part of a traffic citation stop, right? At that time, 16 people in LA had died from chokeholds by the LAPD, 12 of them black men. He sued, and the Supreme Court said, I'm sorry, Mr. Lyons, you actually can't bring this action for damages for your injuries. Why? Because you can't show that you personally would be likely to be choked again in the future, right? So the court said, as a result, he had no more standing than any other citizen of LA, and that you must show a likelihood of future injury to get standing. So when I say it's stacked against identified lives, right, there's a hyper-identification here. One more case, in part because it's the leading case on this doctrine now, another case against Lujan Defenders of the Wildlife. So we've got a federal regulation that said the Endangered Species Act, which protects, much unloved species, not the cute ones, but often the ones you've never heard of, does not apply abroad. So we're told that this does not apply abroad, and somebody wants to challenge it. So two plaintiffs, they read this case law, they've got good lawyers, they put forth detailed affidavits about past trips abroad to view endangered crocodiles on the Nile, right? And the court says, well, I'm sorry, that's not good enough for us again. The fact that you've been there in the past, the fact that you desire to return, quote unquote, someday in the future, proves nothing. What we need is the description of a concrete plan, a specification of when that someday will be, and if you don't do that, you can't bring your action. Okay. So what is the effect of this? I mean, so okay, I'm making it sound like the Supreme Court is just a group of 9 meanies that want to throw people out of court whenever they can. And, you know, I picked some particular ones that I think will maybe stir up some political sympathy. But there is actually a reason for this doctrine. The reason for this doctrine has to do with, one, the separation of powers, the view that the Constitution requires a case or controversy, and the notion that we don't want the courts to be shooting their mouth off on what's known as advisory opinions. The notion that we want fully fleshed out cases. Why do we want fully fleshed out cases? One is we think that the quality of the argument will be stronger if somebody has a direct stake in it, right? If it's an individual who is directly identified and will suffer, the notion is that we're going to get better briefing. We don't want people bringing forth claims just to throw them intentionally or to do a bad job of them. The other is the notion that it's a respect for the other branches not to have judicial review until we have a live controversy that has kind of manifested itself. And the notion also that we're going to get better fact revelation, a better record, when we have somebody and we have a live controversy that we can decide. So very prudential decisions. Going around with this general favoritism for identified lives in the standing doctrine, more specifically, there's also a limitation to third-party standing. So generally, the court has said an individual can assert only his own right and not that of a party not before the court. And again, the theory is that that individual who you're fighting on their behalf, they may not want the victory, or they may want to argue it a different way, and there's a sense that it will have a better fit between the person arguing and the interests of the individual who the court has to decide if we do it this way. Still, they recognize a few exceptions here. When a third party is unlikely to be able to sue, then you can bring third party standing. So a white defendant, for example, can assert the rights of African Americans who were excluded from a grand jury that indicted him, because the view is those people who were excluded have no ability or incentive to sue. Another is where there's a close relationship between the plaintiff and the third party. And the most famous example here is Roe v. Wade and the contraception cases, in that doctors are often allowed to sue on behalf of their patients in abortion regulation, not because the injury is to the doctor, but because of the closeness of the relationship. So there is some bending here, but for the most part, the basic rule is you can only bring your own claim. That claim, the injury to you has to be direct, it has to be imminent, and that pushes us towards identifiability. A second related doctrine is known as ripeness. If standing is about who can bring a claim, ripeness is about when someone who can bring a claim can do so, so a temporal aspect. And basically the question here is whether you can sue before the injury happens or not. Now that has an obvious relevance and connection to the whole prevention treatment discussion from yesterday that's often here. And in deciding whether a case is ripe, the court looks to the hardship to the party in withholding court consideration and the fitness of the issues for judicial decisions. Again, the motivation is maintaining separation of powers by avoiding judicial review in situations where it will turn out not to be necessary. Also, it conserves judicial resources. It enhances the quality of judicial decision-making by ensuring there's an adequate record. So again, just to give you a couple of examples from the Supreme Court on the matter, in Adler versus Board of Education, we had a New York law that disqualified individuals from teaching in public schools if they were members of a list of subversive organizations. And some people brought a claim to challenge it. What the Supreme Court said, listen, that case isn't ripe before anybody was disqualified, right? So that was the argument that was being made, and the Supreme Court rejected that. They said, technically that's true, but it's too much of a burden to say to someone, first you need to get disqualified and lose your job, and only then can you bring the challenge, right? There was a fear of a chilling effect, the notion that people wouldn't behave. But in another case, an earlier case, United Public Workers v. Mitchell, federal employees sought to challenge the Hatch Act of 1940 that prevented federal employees from being part of political campaigns. So again, a very similar kind of setup. But the court said, listen, listing the activities you want to engage in, prohibited by the statute, was not enough. Instead, you actually have to do it and then get sanctioned under the Hatch Act. So the Supreme Court has kind of gone back and forth about whether we're going to actually force people to get slapped on the wrist or otherwise set back their interest before they can bring the action. Also, the speculativeness of an injury can be a problem for ripeness. In a case known as Reno versus Catholic Social Services, challenges to immigration regulation were brought, and these particular immigration regulations require that before you can get a green card, you need to apply for temporary residency status. So Catholic Social Services wanted to challenge the law on behalf of individuals, but the court said it wasn't ripe because it was speculative that any member of that class would be denied legalization due to the new regulation. And to make it ripe, someone would actually have to apply for legalization first and then be not denied. So again, this line of cases make bringing a challenge to probabilistic harms and to advance harms that haven't occurred yet difficult, and therefore emphasizes a preference for identified lives over statistical lives, to the contrary of sort of the discussion of environmental law and public health law here. Okay. So that's the discussion of the problem. Now let me tell you a way in which civil procedure, again, accidentally, this is not its aim, gives us a partial solution. And that partial solution is the class action device. So a class action is when a class representative files the action, just like a normal plaintiff, on behalf of a set of claimants, a class who are not before the court, right? So it's me on behalf of individuals. Here are a few from my own practice experience. I'm going to come before the court on behalf of all individuals in the main jail system who will be subject to, have been or will be subject to strip search upon arrest. So that's a class, right? Another example is I'm going to bring an action on behalf of all individuals who were recognized members of Indian tribes at the time of the Dawes Act in the 1860s and who were defrauded by the government in terms of treaty, right? So the notion is that you have one person who is a member of that class coming before the court on behalf of that class. And that's the notion of representation. Now this gives the legal system a bit of a stomachache. On the one hand, we want to be able to get these people into class actions. Often class actions are used for things that are very low remunerative, right? If every individual had to sue individually, it would not be worth their time. They wouldn't be able to find a lawyer to do it. On the other hand, we have this tradition of believing that any individual ought to have their day in court. We want due process protections. And if you lose the class action, you're a member of the class, you're going to face preclusion. You're not going to bring it on yourself. So we have this idea of one person steering a ship, but the whole ship may either sink or make it to the other shore. And there's a notion here that we're trying to balance these two things. And what we do basically is we have this process known as certification, wherein we try to decide whether a class action is the appropriate way to bring it, where we try to balance these two interests. One between efficiency and representation on the other hand and access, and the other about due process and these concerns. And in many ways I want to suggest some of this inquiry actually dovetails nicely to the topic of this conference and gives us a way of thinking about this intermediate category of a representative life. So the first requirement about the class is that there's about 6 requirements. They must be identifiable or definite. That means the class of people for whom you're bringing this action must be precise, objective, presently ascertainable. And determining who's a member of the class should not rest on subjective criteria, nor should it require the court to engage in too much factual development. You can fail this requirement if the class is too broad, too specific, too vague, or too amorphous. It's a bit Goldilocks-like. So to give an example from a case I teach about Michigan high school athletics, a class that met that requirement was okay. All present and future, again, statistical, probabilistic, right? All present and future female students enrolled in Michigan High School Athletic Association member schools who participate in interscholastic athletics or who are deterred from participating in interscholastic athletics because of defendants' discriminatory conduct and who are adversely affected by that conduct. The question was about the funding of girls' sports in Michigan high schools, right? So one individual, and in fact it was an association, was allowed to stand in for all of those people who are adversely affected or would be adversely affected in the future. And again, the question is whether can I know objectively who is a member of the class? I don't need to know the identity of each member before certification. All I need to know is at the end of the day, at some stage of the proceeding, will I be able to go back and know who those people are or who those people will become, right? And you ask things like whether it's administratively feasible. Is it a manageable process? Does it require individual factual inquiry? And things like, you can inspect a corporation's book to reveal the owners of common stock. But on the other hand, if you needed to do an individual inquiry into the form of title searches for every property holder in a 300-mile zone over a 200-year period in order to know who's a member of the class, that's no good. Those are two pretty broad boundaries. It gives you a sense of this, right? And this has come up a lot, in particular in toxic tort cases. There are very difficult questions about toxic tort cases in that the injuries may not have manifested yet. Causation is difficult. But again, that first requirement of identifying a class goes a lot to this notion of an intermediate notion of representation between identifiability. The class representative has to be a member of the class. That's usually pretty easy, although there's some deeper, difficult, more philosophical questions. So in Brown v. Board of Education, right, the class was all people enrolled in the school districts, right? Well, in those school districts, you had people who were for segregation and people who were for desegregation, right? And there was an interesting question about whether the class member in that kind of case can represent the representative, who they're representing, and how we set up the class. There's a requirement of numerosity. We only use class actions when the classes are large. Usually over 40 people is the sort of the threshold. And then I think what's most interesting from our purposes is two requirements, one known as commonality, one known as typicality. So you need to show that there are common questions between the representative and the class, right? This particular requirement, if you're seeking damages, it's a heightened requirement, but if you're just seeking an injunction or the like, having some common questions is usually enough. Although last year in the Walmart decision, the Supreme Court, this was a case about employment discrimination about against 1.5 million Walmart female employees. The Supreme Court pushed back on this and suggested that actually, even though they are all claiming devaluation of their work and less payment, that's not enough. You needed something more common, like saying this particular policy in this particular store that applied to me. But the notion here, again, is if there's commonality, adjudicating the interests of the representative will be a good way of getting at the statistical unrepresented lives back there. Similarly is the requirement of typicality. And again, this is the notion that the claim of that individual shouldn't be special. It shouldn't be special in terms of really good in particular ways that are legally relevant, or really bad in that it's subject to particular types of defense. How representative is this representative of the larger class? And then there's lastly a requirement of adequacy of representation. So again, taking a step back from the doctrinal landscape, what do I want to leave you with? One is the notion that the system in place currently, because of preferences for separation of powers, concreteness, judicial efficiency, has a strong preference for identified over statistical lives. That's the standing and the ripeness doctrine. At the same time, the class action can be a limited way of overcoming this by allowing one identified person to stand in for a larger group of statistical individuals. And in that notion, I think there might be something useful and interesting from the philosophical standpoint of something in between an individual identified life and a statistical one, which is a representative, right? They share some bonds, we know something about them, and we can reason and marshal the kind of biases we have towards identified lives as to the one identified individual, but treat them as a representative of the larger class of statistical. Great, thank you very much.